information, simply go to booktv.org.
Next, a discussion on international law and how it affects women in the Arab and Muslim world. Justice Sandra Day O'Connor took part in this 90-minute forum in September at the Supreme Court.
Justice Sandra Day O'Connor, dear friends of the Hannibal Club USA, it has been traditional at the Hannibal Club USA that Ambassador Peltro, President of the Board, or myself open our monthly events. But you see, today's event is a feminine nature, and the stage is almost feminine. And I can see that we are defeated and reduced to a minority. Allow me in the beginning to express my gratitude to Justice Sandra Day O'Connor, who made this event possible and will be conducting it in this majestic room of the Supreme Court, where she was the first lady to be nominated, thus opening the door of the highest institution of the United States. Today, this great lady will be leading this debate on women's rights in Arab Muslim countries and the Tunisian experience as it is implemented since the promulgation of the law of August 13, 1956, first law passed in independent Tunisia that consecrated women's rights in a modern society. This debate is held in an international context that is genuinely optimistic, and the Hannibal Club USA is proud to be one of its organizers. America has no inherent opposition to the real and wise Islam. It is this Islam that the First Lady, Mrs. Hillary Clinton, paid tribute to in the Middle East, in the Maghreb, and particularly my country, Tunisia. I would like to thank our numerous guests who remind us each time that neither Hannibal, who in spite of his 2,250 years age, nor his message has become old-fashioned. To you all, I would like to convey the gratefulness of President Ben Ali, who does consider Hannibal Club's activities a deepening of Tunisian-American relations. I would like also to thank Mrs. Teresa Law, Director of the President's Interagency Council on Women at the State Department, who has spared no efforts in organizing this event with us, and that she will be moderating today. I'm grateful to the panelists surrounding Justice O'Connor, Professor Dr. Aziza Al-Hibri, Judge Aqila Jaraya, and Mrs. Huda Kanoun, member of the Tunisian Parliament. I now yield the floor to Mrs. Teresa Law. Thank you very much for being here, and thank you very much for your attention.
Welcome to the Supreme Court for a forum on women in international law, a closer look at women in the Arab and Muslim world. We are delighted today to begin this program. Today with us is a distinguished audience, including a number of ambassadors from the diplomatic corps, leading experts from the legal and foreign policy community, members of non-governmental groups, and prominent representatives of the Muslim American community. A special welcome to my colleague, legal advisor to the Secretary of State, David Andrews. We are very grateful to the Hannibal Club for hosting this event, for Ambassador Medjdoub and his embassy team for their wonderful work, and to Duria Ghati Ali, who works in my office and through her expertise on women in the Islamic world is shaping policy throughout the State Department. A special note of appreciation to Justice Sandra Day O'Connor, who so graciously has opened the Supreme Court building to all of us to make this space available for discussion of this important topic. Her interest in this issue and in speaking in the program today has already lent great prestige to the subject. As noted in our program, we look forward to the question and answer period following the panelists' remarks. We have supplied the audience with papers and pencils, and please write any questions you may have for our distinguished speakers and pass them to the end of the aisle. I would like to start our program by inviting my friend Milan Vivier, Assistant to the President and Chief of Staff to our First Lady, to join us by delivering a message from Hillary Rodham Clinton. Milan is known as one of the leading foreign policy experts in the White House, and through her work and leadership in traveling around the world as the First Lady's senior advisor, she has played a key role in bringing issues affecting women into U.S. foreign policy and onto the world stage. Milan Vivier.
Thank you, Teresa, and thank you to Justice O'Connor for hosting this, and to the Hannibal Club. It is a pleasure to be able to bring you greetings from the First Lady. Dear friends, I am pleased to have this opportunity to send greetings to each of you gathered today under the auspices of the Hannibal Club USA for this discussion on women in international law, a closer look at the Arab and Muslim world. I especially want to thank Justice Sandra Day O'Connor for her leadership in this endeavor. Earlier this year, I was privileged to travel to Tunisia on behalf of our country and to see firsthand the progress that is being made there, especially on behalf of women's development. In this respect, Tunisia is a model, not just for the Arab world, but for the entire world. There, I met with women from all walks of life who told me how significant the personal status code and the family status code are in providing important rights and protections under the law. However, the women with whom I spoke did not take their rights for granted. They knew that the rights and protections of the code could one day be threatened, and the struggle for equality should never be abandoned. I have been impressed and inspired listening to the stories of Muslim women in many parts of the world, from Senegal and Tunisia to Southeast Asia and beyond. Each of these women shared the common goal of working to make life better, not only for themselves, but also for their families, their communities, and their countries. Please accept my best wishes for a stimulating discussion and my thanks for your work to expand the circle of human dignity. Sincerely yours, Hillary Rodham Clinton.
Thank you, Milan, and thank you, Mrs. Clinton. I feel fortunate to work with such a dynamic leadership team of the First Lady and my boss, Secretary of State Madeleine Albright. Secretary Albright has said that in advancing the status of women and standing up for women's human rights around the world, we're doing not just the right thing, but the smart thing. The subject of women in Islam is receiving greater attention in the West. Muslim women from around the world are re-examining the notion of increased rights for women in Islam. We are fortunate that Justice O'Connor is now joining this discussion from a legal perspective by putting this within the framework of international law. It is now my great privilege and honor to introduce our keynote speaker. We all know that Sandra Day O'Connor was the first American woman named to the Supreme Court, having served now for 18 years. In addition to her distinguished service on the Supreme Court in the United States, Justice O'Connor is a pioneer in the international arena and has opened dialogue with international judiciaries around the world. She recently led a delegation from the Supreme Court and federal and state courts on a visit to courts in Europe. Through her work here on the court and her participation in programs such as this program today, Justice O'Connor's impact and influence are felt around the world. Please welcome our keynote speaker, the Honorable Justice Sandra Day O'Connor.
very much. And welcome to all of you. I wish we had more space, but people like sometimes to visit the Supreme Court, and I feel very privileged that I could participate in this meeting today and sponsor the availability of these rooms for that purpose today. And you are all most welcome here. And Ambassador Medjugorje and Mrs. Lohr and my fellow panelists here and distinguished guests, I'm very pleased to be invited to make some remarks today on a subject in which I take considerable personal interest, the legal and social status of women. And I would like to thank the Ambassador and the Hannibal Club and the President's Interagency Council on Women for providing the forum to discuss and promote women's issues. Women from all countries have a great deal to share with each other about their own cultures, experiences, successes, and failures. Today, as always, women are the primary caregivers worldwide. We bear and nurture the children. We manage the household for our families, but we also work outside the home. We want and expect to have equal opportunities in business, in the professions, and in public service. We want and expect to be paid as much as men for the same work. While women have made tremendous strides and advances in this century, the process of achieving gender equality is still an ongoing one in this country and around the world. In many respects, we've traveled far, although we have still a way to go. We remember the old adage that the test of every civilization is the position of women in the society. Although the experiences of every country are unique, the path taken by American women can offer useful insight, I think, to the international observer. Here, as always, the past serves as prologue. The situation of women in 19th and early 20th century America demonstrates just how far we've traveled. When Abigail Adams, the wife of our future President John Adams, implored her husband in 1776 to remember the ladies in drafting our nation's new Constitution, her remarks fell on deaf ears. John Adams dismissed her plea, prompting her to respond that I cannot say that I think you very generous to the ladies, for whilst you are proclaiming peace and goodwill to men, emancipating all nations, you insist upon retaining an absolute power over wives. The American Constitution, which was signed in September 1787, was produced by 55 men, and they did a pretty good job. Although subject to the Constitution's terms, however, women were unacknowledged in its text, uninvited in its formulation, and unsolicited for its ratification. To be sure, the provisions of the Constitution were broadly framed and did not textually aggravate the plight of women. Nonetheless, it's fair to say that in setting out the contours of American government in 1787, the framers of our Constitution envisioned no role, officially, for American women. Nor did the ratification of the Bill of Rights in 1791 have much effect on the legal status of rights of women. Although the Bill of Rights did not specifically deny equal rights to women, its authors did not contemplate meaningful protection for them either. The carefully drawn limits of the Bill of Rights circumscribed only the federal government. The states were free as before in fashioning political and legal rights of their citizens. The states drew their legislation primarily from the English common law, which was based on a tradition in which gender defined the geography of social life. As the great political observer Alexis de Tocqueville described it in the 1830s, the Americans have applied to the sexes the great principle of political economy, which governs the manufactures of our age, by carefully dividing the duties of man from those of woman in order that the great work of society may be the better carried on. Men dominated the public arena of political and commercial activity. Women, for their part, occupied the private realm of domestic and spiritual life. That notion of two distinct spheres for the genders had firm roots in the belief, embraced by virtually every major theologian and philosopher of that time, that women were subordinate, probably less intelligent, and definitely weaker. By law, wives could not hold, purchase, control, bequeath, or convey property, retain their own wages, make contracts, or bring legal actions. In the words of the English poet, Lord Tennyson, a wife stood in legal relation to her spouse as something just better than his dog, a little dearer than his horse. The law reinforced a rigid distinction between genders and did so most vehemently with respect to women's efforts to join the bar and to practice law. In 1869, Myra Bradwell applied to the Illinois bar and was denied admission. She appealed that decision all the way to this court. In 1873, the court agreed that she was unfit for the practice of law. 3 concurring justices expressed the view that man is or should be woman's protector and defender. The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life, they said. The marital relationship during this same period, as reflected in law, was characterized by male dominance as well. On marriage, women suffered what Blackstone termed civil death, as their individual identities merged into their husbands in the eyes of the law. The married woman by herself was often legally classified with lunatics, idiots, and infants. Men were under a legal duty to support their wives, but the law rarely stepped in to enforce the obligation. Judges took a similar stance toward domestic violence. Early English law had recognized the husband's right to discipline his spouse, provided that he neither killed nor maimed her. This, then, was the situation of American women until all too recently. They could not vote. They were excluded from the working world due in part to their supposed physical and mental inferiorities, and in part to notions of their moral superiority, which required their protection and insulation from economic competition and political affairs. They generally lacked the power to own or sell property. Their husbands were their undisputed legal masters, socially and legally. America reflected and reinforced a highly gender-stratified order. Against this backdrop, it is certainly clear that women in my country have come very far indeed. In my own lifetime, I have witnessed literally a revolution in the legal profession that has resulted in women comprising nearly 30% of attorneys in this country and over 40% of recent law school graduates. This progress is truly amazing when you consider that at my graduation from Stanford University Law School in 1952, near the top of my class, the only position I was offered at a law firm was that of legal secretary. Now, in the span of a few decades, my options have blossomed. I've served as a state senator, a state court judge, and a United States Supreme Court justice, and it is astonishing to contemplate how much change has occurred so quickly. It was not until after our Civil War in this country and the adoption of the 13th, 14th, and 15th Amendments to our Constitution that there were national guarantees for certain individual liberties that the states could not abridge. But even those additional protections and provisions did not easily translate into concepts that benefited women. Passage of those amendments, however, inspired a sense of unity and of identity among American women that gave life, really, to the women's suffrage movement. Suddenly, the right to vote became much more than a crumb. It became everything that women wanted to focus their attention on. And securing the right to vote through the ratification of the 19th Amendment to our Constitution in 1920 was the outgrowth of a remarkable alliance between progressives who touted women's need for protection in the workplace and pioneer feminists like Elizabeth Cady Stanton and Susan B. Anthony, who wanted full and equal citizenship for women. Passage of the 19th Amendment, giving women the right to vote, remains the single greatest political triumph of the women's movement in the United States. Despite the extension of the vote to women, many laws continued to enforce the exclusion of women from much of the working world. And change in that area at the workplace really came about after the passage of civil rights legislation by Congress in the 1960s. And it arrived partly by accident. The Civil Rights Act of 1964 was an outgrowth of our concerns about racial discrimination. It was passed at a time when women's issues were not at the forefront of public attention. Indeed, the part of the act that prevented gender-based discrimination by employers was not part of the original legislation at all. As the story goes, a congressman named Howard Smith introduced an amendment offering protection against sex discrimination in a last-minute effort to defeat the whole civil rights bill because he thought that none of his peers would vote for protection for women. And when the amendment passed, it passed both houses, and Congressman Smith became an unwitting hero of the women's movement. The late 1960s and the early 1970s were a period of great activity in regard to women's issues here. In a series of cases addressing laws that discriminated against women, the Supreme Court of the United States made clear that it was no longer going to accept the story that women are fundamentally different than men with respect to review of laws. And the court invalidated a broad range of statutes that discriminated on the basis of gender. Until 1970, the court generally assumed that state legislatures and Congress did have good reasons for writing sex-based distinctions into laws. After that time, the court refused to accord the presumption of validity to such laws, and in all cases since then has looked skeptically at loose-fitting generalizations and stereotypes that previously kept women at home. And the court since then has looked instead to individual assessments of job qualifications rather than over-inclusive generalizations of the past. And thinking about where women in this country started and where they are now and how they got there, I've been struck by the parallels to that journey toward gender equality traveled by women from other countries and under international law. As in this country, early efforts to secure equal treatment of women under international law grew out of the women's suffrage movement. The League of Nations endorsed several conventions for the protection and promotion of women's rights in the early part of this century. Prior to World War II, however, international law focused primarily on relations between nation states rather than on individual human rights. The creation of the United Nations provided the first real mechanism to ensure individual rights under international law. The Charter of the United Nations, which reaffirms the equal rights of men and women, was the first international agreement to proclaim gender equality as a fundamental human right. The Universal Declaration of Human Rights, which was adopted by the United Nations General Assembly in 1948, proclaimed that all human beings are born free and equal in dignity and rights. The initial drafts of the Declaration were not that inclusive, however, and said only that all men are born free and equal. When the original draft was debated, Eleanor Roosevelt, who then chaired the Human Rights Commission, the UN body charged with drafting the Declaration, initially argued in its favor, noting that all men really meant all human beings. The other women delegates insisted, however, that the language be changed. They argued that if we say all men, when we get home, it will be all men. The women's lobby ultimately prevailed, giving us the Universal Declaration that we recognize today. The principles in the United Nations Charter and in the Universal Declaration of Human Rights, like our own Bill of Rights, are not self-enforcing. Instead, they have to be transformed into treaties to make them legally binding on the ratifying countries. Even then, these treaties or conventions rely for their enforcement in each country primarily on political pressure and on public acceptance of the values that the treaties seek to promote. Attempting to put these lofty principles of equality into practice in the daily lives of women around the globe was and remains today an enormous challenge. In the early years of the UN, the focus was on codifying women's rights to address the legal barriers they faced in the public sphere of their lives, improving educational opportunities, allowing property ownership, improving employment conditions and pay, and securing basic political rights such as the right to vote. The next step was to address customs and practices that were harmful to the health and well-being of women and girls, such as forced marriage and child marriage. To date, United Nations bodies have produced more than 20 different international legal instruments dealing specifically with women. The biggest challenge, however, was not simply to codify these rights in international treaties, but to somehow make sure that women could actually exercise those rights. Largely through the efforts of non-governmental organizations and through a series of UN-sponsored world conferences on women, the concept of women's rights as human rights began to emerge in the 1970s. These principles found their expression in what has been called the International Bill of Rights for Women, the Convention on the Elimination of All Forms of Discrimination Against Women. The acronym for that, everything in Washington has an acronym, is CEDAW. Now, it entered into force in 1981, and CEDAW is the most comprehensive and detailed international treaty to date addressing the rights of women. It seeks to codify women's equality and to promote women's participation in the political, social, and economic fields. Not all nations have approved and ratified CEDAW. Indeed, the United States has not done so. It is clear from this short recitation that the legal status of women under international law, like the legal status of women in this country, has seen tremendous change in this century. Although there are a wide array of legal institutions in place to protect the legal rights of women, the ultimate responsibility for promoting equality must rest with each of us as citizens in our own countries. I think we can draw a few lessons from our experiences that may be useful for women across national and cultural borders. I see 3 lessons about the relationship between democratic institutions and public opinion. First, change, whether by court or by legislature, has a much better chance of succeeding when it follows rather than leads public opinion. Women have been quite effective in the United States in obtaining legal protection against discrimination, sexual harassment, and domestic violence. But it means very little if the public is ambivalent about its necessity or its wisdom. And I think that lesson is true on the international scene as well, where many organizations have worked hard to promote gender equality. Second, our experience here shows that all of us as women must participate in political life. It is not enough to build a constitution and democratic institutions, even an independent judiciary. Women have to be active in parliaments and local politics to help shape the public policies that will affect them as citizens, as workers, as wives, as mothers and daughters. And the visible presence of women in significant positions has a real effect on the lives of other women who are out there trying to advance professionally and personally. Now, finally, I think the experience in the United States shows that dramatic change occurs only when members of a large group, such as most women, surmount their individual differences and unite in the pursuit of a common goal. And the two most significant accomplishments in this country, winning the vote and getting entry into the employment sector on a mass scale, were the products of a rare consensus among women in this country from various philosophies. And it has only been when we've, as women, have cast aside our respective differences in political views and forged common ground that we've been able to achieve meaningful change. So building a consensus for liberty and equality of all people depends at bottom on custom and tradition and the efforts of millions of ordinary citizens. We as citizens have to be committed to working together to achieve our goals and make them work in practice. And all of us as women must help to work out our own community problems. I think that society as a whole, whether American, Tunisian, or any other, can benefit immeasurably from a climate in which all people, regardless of gender, have the opportunity to earn respect, responsibility, advancement, and remuneration for work based on ability. So we still have challenges in all our countries, and Tunisia can rightly claim to be a pioneering state with regard to women's rights among the Arab states of North Africa and the Middle East. It was the first Islamic country to abolish polygamy and restrict the husband's traditional right of repudiating the marriage at will, and to raise the minimum age of marriage. And it gave women the right to vote and hold office. The progress that Tunisia has achieved in instituting legal rights for women serves as a guidepost for other nations as well. And I think that success for women throughout the world depends on changing minds at home and in the streets and in the workplace, not just in legislatures and in courts. So each of us has an important role to play in completing that task wherever we might live and work. Thanks so much for being here today.
Thank you very much for your comments, Justice O'Connor. You've certainly gotten this discussion off to a very lively start. Our next panelist is Dr. Aziza Al-Hibri, a professor of law at the University of Richmond and founder of Karama, an association of Muslim women lawyers for human rights. Dr. Al-Hibri is a noted scholar and has published extensively on the subject of women's rights in Islam. She just returned from an extensive trip to 9 Muslim countries. Please welcome Dr. Aziza Al-Hibri.
Thank you, Teresa, for your unlimited energy and insights in making this event happen. And thank you, Justice O'Connor, for all you've done for all women at home and abroad. I'd like also to thank the Hannibal Club. After all, Hannibal was born in Carthage, a state established by a woman who, like myself, emigrated from the shores of Lebanon. Friends, let me quickly turn to the topic at hand by introducing Islam. Islam is very much, just to give you a short definition, very much like Einstein's theory of relativity. Everyone talks about it, very few people understand it. So I start by introducing the fundamentals of Islam, a religion based on the Quran, which is the revealed word of God. The fulcrum of all Islamic faith is the unicity of God. To deny this unicity is to engage in shirk, that is, positing another deity with God, an unforgivable sin in Islam. From that follows all of Islamic law, and in particular, the superiority of God's will to our own will or whims, whether personal or cultural. God created all humans from a single male and female, who in turn were created from a single nafs or soul. No human is more favored in the eyes of God than another, except by virtue of one's piety. As the Prophet puts it, people are equal like the teeth of a comb. Unfortunately, according to the Quran, Satan did not understand these basic facts. In the story of the fall of Satan, God created Adam and ordered Satan, or Iblis, to bow to Adam. Satan refused. His reason was simple. How could he possibly bow to Adam if he is better than Adam? This satanic logic, rooted in arrogance, caused Satan to disobey God and incur God's wrath. By disobeying God, Satan set his own will as equal or superior to divine will. He thus violated the basic principle of Islam, namely the unicity of God and the superiority of God's will. He fell into shirk. The medieval jurist Al-Ghazali concludes from the story that a rich person who thinks he is better than a poor one, or a white who thinks he's better than a black or a red person, or, I interject, a man who thinks he's better than a woman, is guilty of satanic logic. For after all, the Quran is clear about the basis for the divine preference of one person over another: piety. Incidentally, in the Quran, Eve was not responsible for Adam's fall. Rather, both Adam and Eve suffered from the same human condition and were seduced by Satan to eat from the tree of power and eternity. This represents yet one more building block in the egalitarian ontology of Islam. We now turn to the duties and obligations of Muslim men and women. In matters of worship or ibadat and related matters, generally Muslim women have equal rights to men, including the right to pray in a mosque, perform pilgrimage or hajj, interpret the Quran, engage in jurisprudence, and even give fatwas. Women have been engaged in one or more of these types of activities for centuries, from Aisha, the wife of the Prophet, to Al-Dahma of Yemen, to Kulthum bint Umar of Cairo. Local custom, however, has increasingly interfered with women's activities. Today, for example, the Taliban have chosen to prohibit women from the robust pursuit of education. Clearly, Afghani women cannot study the Quran and interpret it if they cannot read. How can the Taliban square this position with the Quranic verse which exhorts Muslims to ask God to increase their knowledge, Rabbi zidni ilman, or with the fact that the Prophet engaged a teacher for his own wife? Clearly, some Muslim countries are rapidly moving backward. In matters of mu'amalat, or transactions and dealings with others, the Quran clearly guarantees the woman many rights, such as the right to work, the right to education, the right to participate in the political process, the right to own property, and the right to inherit. The Quran asserts that men have a share of their earnings and women have a share of their earnings. Thus, the Quran does not limit the woman's ability to earn. Rather, it treats it as parallel to that of the man. Yet Muslim countries continue to make it difficult for women to work. In Syria, for example, a working woman runs the risk of losing her maintenance if she works without her husband's consent. Egypt and Kuwait do not require such consent so long as the job is permissible and does not harm the interests of the family. I'm puzzled by this condition. Does Islam permit the husband to take any job, even an impermissible one which harms the interests of the family? If not, why then do we continue to legally burden the women's work choices while honoring those of the man? Is not that another form of paternalism? In many Muslim countries today, women are still negotiating their right to participate in the political process, even though it is reported clearly in the Quran that the Prophet himself accepted the bay'ah, which is a form of election, from women at that time. We are told that women cannot be political leaders because they cannot lead in prayer. Yet we know that the Prophet asked a woman, Waraqah, to lead prayers. Imams Abu Thawr and Al-Tabari of the old times concluded from this incident that a woman may therefore lead men in prayers. But many jurists limited the significance of the incident, while others argued that it was highly specific and cannot be generalized. This is still a very controversial issue among Muslims. Closing their eyes to a vibrant history of Muslim female participation in politics, many Muslim societies continue to drag their feet. Well, perhaps they need another Muslim queen, like Queen Arwa of Yemen, to help them settle the issue. Another fact worth noting is that Muslim women are often being denied by their own families their legitimate right to inheritance. I have heard one too many stories about mothers coercing their daughters into signing away their inheritance share to the brother. What is needed today in Muslim countries are courts that protect daughters from such coercive behavior. After all, the Quran specifies a share for the woman. All these discrepancies between the Quran and the practice of Islam in Muslim countries point clearly to the fact that many Muslim countries and societies, while claiming to be bound by Islamic law, are in fact reverting to patriarchal customs and often using religious claims to justify these customs, which were rejected by Islam specifically many centuries ago. The denial of education has had a particularly pernicious effect of silencing pious women. Unable to distinguish between truly religious mandates and customary patriarchal prejudice, pious women have often opted to remain silent, thus further empowering local patriarchy and participating in their own oppression. Let us look at another Quranic right of women in action. According to a majority of Muslim jurists from medieval times, the woman has the right not to enter a marriage without her consent. Yet various Muslim countries today, not including Tunisia, require the woman to have a wali, a guardian, to conclude the marriage contract on her behalf. This is amazing, since many of these countries follow the Hanafi school of jurisprudence, and Abu Hanifa himself recognized the right of the woman to contract her own marriage. In traditional Islamic jurisprudence, the marriage contract is not regarded as a service contract. Rather, it is regarded as a contract for companionship. Consequently, the woman is not obligated to cook, clean, or otherwise serve her husband. In fact, her husband is obligated to bring her prepared food. These facts follow directly from the Quranic definition of the relationship between spouses as one of mercy, affection, and tranquility, not one of domination. Husband and wife are each other's garments. That is, they shield from public view each other's shortcomings. The husband, therefore, may not discuss private matters concerning his wife with others. The husband is also instructed to stay with his wife in kindness or part ways charitably. Muslim divorce cases in the United States and across the world show that in many cases, husbands violate this very basic Quranic injunction. Let me focus on one more right granted to women by Islam. The Muslim woman is entitled to be financially independent. Neither her husband nor father may touch her holdings. Furthermore, the Quran engages in affirmative action on behalf of women to help them accumulate wealth in a patriarchal world. For example, the woman is not ever obligated to spend any of her own money to support herself. The obligation usually rests on the shoulder of some male in her family. Of course, she may decide to waive that obligation, but that is up to her. While the woman does not need to spend her own money for maintenance, she may accumulate money through a variety of ways, such as work, marriage, and inheritance. It has often been argued that the Quran gives the Muslim woman half the inheritance of the man. This is false. The relevant verse speaks only of siblings, and the rationale for giving the sister half of what the brother inherits is missed by looking at the verse in isolation as opposed to studying the whole Quranic financial social system. There is only siblings. In that case, the woman gets half of what the brother gets. In all other cases, there are other formulas. Given the totality of this system, what the sister inherits under the Quranic law is net income to her. Net income to her. The brother's share is gross income, which he uses to meet his maintenance obligations towards his children, elderly parents, wife, and others. The woman has none of these obligations, regardless of her financial status. The problem is that the courts are not enforcing this part of the law. Unfortunately, some men use their maintenance obligation to turn the woman into a ward. They hang that on a particular Quranic verse which states in part that men are, and I'll use the Arabic word, qawwamun over women. Heard it so many times. Men have traditionally interpreted this verse to mean that men are in charge of women or even superior to them. This is a gross misreading, which conflicts both with the Quranic principle of equality, which I described to you, and the purpose of the affirmative actions specified in the Quran. Taking a closer look at the verse, we find at least two things. First, that the word qawwamun means to advise, to take care of. Second, the verse states a limitation. This is not a privilege to men. This is a limitation on men, not a permission for them to act that way. It limits their advisory function to cases where two conditions are simultaneously satisfied. First, the man is supporting the particular woman he is purporting to take care of or advise. So this is not a general thing about all women and all men. And second, he has a greater edge in the subject matter of the advice. If she knows more, then he better not try. The male status as a qawwam thus does not extend by virtue of his gender to all men. This is exactly what the verse came to deny and to limit. More importantly, if the woman is better informed about the topic of the advice, the male has no standing to offer his. Thus, he may advise the woman on financial matters if she is naive about money, but not if she has an MBA, regardless of whether he is supporting her or not. It is perhaps for this reason that men historically have tried to confine women to the home so that they will be dependent on the male's advice about the real world. In short, Quranic verses protect women's rights, but some have been given a patriarchal interpretation, while others are not even applied. The Tunisian Code tried to deal with this problem by adopting egalitarian principles. For this reason, some have accused the Tunisian Code of being unduly influenced by the French. In fact, official memoranda detail the Islamic foundation of many of the provisions we find in the Tunisian Code. In this, Tunisia is no longer alone. Other countries are making good attempts. For example, the Jordanian and Kuwaiti codes recognize verbal abuse as a basis of divorce. Oman has 2 elected women in its parliament and another 2 in the Consultative Council. Qatar is seriously studying issues of women's rights with an eye towards drafting a suitable personal status code. Muslim women are no longer silent. They are demanding their God-given rights, but they are doing it in the Quranic spirit.
Thank you.
Thank you, Dr. Al-Hibri. May I just remind the audience that Laura and Daria are coming around to pick up questions from the audience that you write on cards and pass to the end of the aisle so we can begin our question and answer period after our panelists are completed. Both of our Tunisian panelists here today have traveled a great distance to join us, and we greatly appreciate their efforts. Huda Kanoun, our first of our Tunisian panelists, has served as a member of parliament for the past 10 years. She has had a distinguished career in public life with leadership positions in non-governmental groups. She was elected deputy mayor of a leading city in Tunisia, and throughout all of her work, she has been a committed advocate for women. Please join Deputy Huda Kanoun. Please welcome.
Thank you, Teresa. Your Honor, Justice O'Connor, ladies and gentlemen, allow me to express my thanks to the organizers of this big event. Ladies and gentlemen, I would like to start with an old African adage that says, when there is little soup, little girl gets none. And another which says, raising a girl is like raising a tree in one's neighbor's garden. This may be right for many parts of the world, but Tunisia, the land of tolerance and openness, has decided otherwise, and that is not surprising. Was Carthage not founded by the famous Halisa? Was El Kahena not ruling Tunisia in the year 75 of the Aegea? And did we not have our famous women throughout history? It is true that these did not belong to any organized movements, but their very existence tells you a lot about my country. Tunisian women began to struggle for their rights in the early 1920s and were helped by the men elite, such as our Tahir al-Haddad, our famous writer. At the same time, they were very active in the struggle for independence. And that's why, as soon as the country became independent, the Personal Status Code, which relates to women's rights, became law on the 13th of August, 1956. And that is even before the proclamation of the Republic in 57. The code stipulates that no girl could be married without her consent. 17 became the minimum age for a girl to marry. Polygamy and repudiation were abolished, and the right of guardianship of minor children was guaranteed to mothers. This provision contributed decisively to put an end to a whole system based on unequal rights between men and women. Other laws guaranteeing women the right to health care, education, employment, equal pay, job security, remuneration, paid maternal leave, and family planning followed. As a result, women got educated and went out to work. But a gap persisted between women's reality and status. Women, for example, were not politically very active, although both the Constitution and the Electoral Code make provision for women's right to vote and hold elective offices. This could well be because they took their rights for granted and did not think that this could be challenged someday. But their rights did get challenged in the 1980s when President Bourguiba, to whom women have owed the code, became too old to govern, and the country plunged into a deep economic recession which gave rise to religious extremism. Indeed, some obscurantists' voices raised against the code. Fortunately, these were met by a strong popular opposition on behalf of the Tunisians and a strong political will on behalf of President Ben Ali to preserve and consolidate these gains. The 7th of November Charters 87, around which all the Tunisians united, announced a new era of commitment to human rights, social equity, democracy, and pluralism. Soon, a law regulating the political party and consecrating the code was enacted. Likewise, a national pact based on the principle of equality among all citizens, men and women, was agreed upon and signed by all the political parties and national organizations in 1988. The 1989 presidential and parliamentary elections were very important, for the Tunisians had to choose between two projects that were incompatible and mutually rejecting. President Ben Ali's project, which was in accordance with an open and tolerant Islam, it aimed at solving the societal and economic crisis by dint of profound reforms, while preserving and strengthening the basis of the modern state and the fabric of civil society. The other project radically challenged the very notion of the modern state. This project had three main targets: the code, of course, women's work, and democracy. President Ben Ali's project won by an overwhelming majority, for it was backed by all civil society. President Ben Ali had the right answer to the crisis. He set up a democracy, empowered women, strengthened solidarity, and enhanced development. Soon, compulsory basic education was voted. Tunisia belongs to this country, which gives human development a high priority. Tunisia spends more than 60% of its budget on social sectors, such as education and health. A ministry for women and the family was set up in 1992 as part of a whole strategy to empower women and promote their integration in the process of national development. On the 13th of August 1992, which women consider, and the whole society as a matter of fact, we as a Tunisian, consider as the code's second birthday, the president announced his intention to amend the code by a series of bills meant to improve women's status. These bills became laws within a year. Among the amendments are the following: the clause providing that a wife must respect her husband's prerogatives and must show him obedience was replaced by both spouses are under the obligation to treat each other with benevolence and assist each other in the management of the household. That is the basis of a new relation between the spouses based on partnership. Mothers have been allowed involvement in their children's affairs, particularly in the case of divorced women who have the custody of the children. Marital violence is punishable, for matrimonial bond is considered as an aggravating factor. A fund for divorcees and their children has been created, and our nationality code too has been amended in order to allow women married to non-Tunisian husbands to give their nationality to their children when these are born abroad. Our vocational training has also been reformed in order to allow young women to attend branches that were usually reserved to men. These bills were only the very beginning of a process, and no later than last July, our parliament has voted a law giving the young couples the possibility to opt for the community of property after marriage. Of course, Tunisia has ratified all the international conventions relating to women, particularly the CEDAW and the Child Convention. As full-fledged citizens, women also benefit from the different programs aimed at the neediest. I would just quote the National Solidarity Fund, which is made by people's voluntary contribution and state endowments to bring infrastructure to the backward areas, and the National Solidarity Bank, set on the same principle, to provide microcredits for those who can't apply for credit from other banks. Today, 80% of the Tunisians own their dwellings. The proportion of working women has risen from 6% in '66 to its present figure of more than 25%, whereas women's projects outnumber 2,000. Life expectancy among women was 73 years in '97. Our current growth rate is 1.2%, and in '97, already 80% of the deliveries occurred under medical control. In '97, 61% of women were already using contraceptive. Child mortality has gone down from 51 births per thousand in '85 to 32 per thousand in '95. As early as '95, our country reached the objectives set by the World Health Organization for the year 2000. As a result, our president was awarded the gold medal of the organization. Tunisia was also awarded the '94 UNESCO's award for fighting illiteracy. Today, 99% of the Tunisian 6-year-old girls are enrolled at school. The rate of girls at school is 50% in basic and secondary schools and 48% at university. Women form 37% of the civil service, 38% of the medical professions, 62% of the dentists, 71% of the chemists, 68% of the vets, 24% of the judges, 17% of the higher council and of the magistracy. In the political field, women represent 5% of the government, 12% of the ministry staff, 16% of the municipal councils, and 7% of parliament. These figures are quite modest, but we intend to do better in our next elections due to take place on the 24th of October. For sure, democracy is a process and always on the make. We are heading towards it. The Tunisian experience is worth encouraging, for it has been able to reconcile women's concerns with Islamic law while respecting the democratic model. I would like to conclude with a sentence by President Ben Ali, who said, "We've done a lot, but we still have a lot to do." Thank you.
Deputy Kanoun, thank you for providing the legislative overview in Tunisia. Now, for a judicial perspective in Tunisia, I introduced Akila Jaraya. Akila has been a judge for 27 years. She's the president of the Chamber of the Court of Appeals, the highest leadership position in the Tunis courts. She served on the Supreme Court for 6 years. Please welcome Judge Akila Jaraya.
Ladies and gentlemen, I'm glad to present to you the Tunisian jurisprudence. Throughout some landmark decisions, this jurisprudence sought to be in the forefront of the movement in favor of consolidating the woman's right. About the right to alimony, the Article 53 of CPS, Code of Personal Status, has placed the wife ahead of others on the list of persons who may require support. Article 23 of the CPS gives her the right to alimony during the course of the marital relationship, and Article 31 of CPS grants life alimony to the woman divorced against her will. Both articles don't make a distinction between employed and unemployed women when it comes to the award of alimony. The Tunisian courts have ruled differently in the matter. Some courts considered that an employed woman who enjoys an independent source of income, doesn't have the right to alimony. It's the decision pronounced by the Appeal Court of the City of Sousse, December 1919. But the Supreme Court considered in a decision that a woman divorced without her consent has the right to a financial compensation in the form of a lump sum or periodic payments, and that this right can't be waived on the grounds that the divorced woman is wealthy or has a source of revenue or for any other reasons. The Supreme Court did, however, allow in another decision that the material situation of the woman can be taken into consideration to adjust the amount of the compensation, but not to deny the compensation altogether. It should be noted that no payment of alimony is considered as a standing or continuous crime. In addition, if the debtor attempts to justify his defaulting by pleading poverty, for example, or illness, it's up to him to prove the hindrance rather than the public prosecutor to prove the defendant's capacity to pay or to disprove the allegations made by the accused, despite the presumption of innocence that the defendant enjoys. In this respect, the joint chambers of the Supreme Court, in their decision 1997, declared that the crime of family abandonment or neglect falls in the category of intentional crimes, but the defendant must justify his default. So our jurisprudence has accepted the principle of reversing the burden of proof from the accused to the public prosecutor to the defendant, with the aim to protect the fundamental right of a wife and her children to a decent living. About the right to the work, Tunisian jurisprudence confirmed women's right to work by ruling that a woman cannot be deprived of work if she is confronted with family obligations. Thus, if a woman is forced to leave her family residence for professional reasons, her husband cannot invoke that as grounds for divorce. In decision October 1995, the Supreme Court declared if the Article 23 of the CPS grants a husband the right to require his wife to live with him in the family home, it's nevertheless unwarranted to consider that this conjugal right negates the wife's basic rights of the wife to work, so long as the wife is compelled by her work to leave her home and promises to return to it as soon as her work allows her to do so. Consequently, leaving her home to work could never be considered as damage which allows the husband to divorce his wife. About moral rights, the Tunisian jurisprudence made a strict interpretation of the articles of the Penal Code with the aim of defending the physical and moral integrity of women. The verdict pronounced by the Supreme Court on June 1987 decided that whereas Article 237 of the Penal Code provides for a sentence of 10 years of imprisonment to be imposed on defendants guilty of kidnapping, abduction, or unlawful seizure, but deception or threat of violence, the expression victim of such crimes in the said article is used without a qualifier. It follows, hence, that the expression cannot be interpreted as applying to a specific category of victims or that it excludes others, particularly victims who happen to be the spouses of offenders. The marriage contract is not sufficient to give a legal character to acts that are otherwise considered as criminal, especially when acts affect the basic rights of women the rights to physical integrity and the right to freedom of movement. The second decision, December 1996, of the Supreme Court, states that whereas Article 228 of the Penal Code doesn't provide that the act or attempt of indecent assault is decriminalized by the mere existence of a marriage contract between the offender and the victim, it follows necessarily that marriage contract can condone only natural and normal sexual acts and doesn't grant the husband moral or material authority over his wife's body to do with it as he pleases against her will, because those abnormal acts affect the physical and moral integrity of the wife. By those mentioned decisions of our jurisprudence, I have attempted to present the role of the Tunisian jurisprudence in the act of the Tunisian woman emancipation. Thank you for your attention.
Thank you, Judge Jiraiya. It is interesting to note that the judge was instrumental in two of the court decisions that she talked about in her remarks. I'm opening the floor now for questions, and I've received some questions that have been collected. Let me start with the first for Justice O'Connor. Justice, in your opinion, do American women still face legal discrimination?
Is this on? Can you hear?
Yes.
Probably not very many laws could be found among the 50 states and the political subdivisions in the cities and counties today that overtly discriminate on the basis of gender. I think most of those have been expunged or amended. I think we see some lingering effects of prior problems. We look around and we see relatively few women in positions of great significance in the corporate sphere. That's changing. We see probably not as many women who are partners in law firms than perhaps we would have thought right now. I think Tunisia may have a higher percentage of women judges on their bench than we do overall in this country. So we have some places to go, and I'm sure there are still some laws that can be challenged, but I think by and large we've corrected the most obvious ones.
Thank you. This is a question for Aziza Al-Hibri. How can the international community and international human rights groups support women's groups in Arab countries without stigmatizing them with association with the West?
Excellent question. The stigma is not really that they're associated with the West. There is no animus against the West generally in Muslim countries. You find the problem when they feel that they're being coerced into making changes along models that are not authentic and not arising from their own culture. I think the best thing that feminist women in the US and other places can do is to help women who are very familiar with the culture and can bridge the gap between the West and the culture. And here I don't mean to make a plug, but Karama, Muslim Women Lawyers for Human Rights, and there are other women's organizations, Muslim women's organizations that I see in the group, who are very familiar with all these issues and can bridge the gap and can work with the locals in trying to interpret Islamic law in a way that is, as it is intended, I believe, to preserve the rights of women. So I would see that this is a matter of alliance, of better understanding what Islam is about, moving away from stereotypes, and listening as much as telling.
Thank you. For Deputy Kanoun, is Tunisia able to share its jurisprudence with other Muslim countries?
Sure. Our jurisprudence has been built on the Quran. And I would like to tell you that the only thing that we, in front of which we couldn't do anything was the heritage, one sort of heritage, not all of them. When the Quran is clear, it says that the women get half the men in heritage. Otherwise, our constitution and our jurisprudence and our law obey to Islam, and we are ready to share them with anyone. Anyone would be welcome.
Justice O'Connor, if CEDAW, the Women's Human Rights Treaty, is considered the most comprehensive treaty dealing with women's rights, why has the United States still not ratified this important treaty?
Well, I think that matter is up before the United States Senate, unless I'm mistaken. And I think I'd be overstepping my proper role if I were to comment on the Senate's prerogative in that regard. I really haven't followed the debates over there, but I assume it's an ongoing matter, and you would know more than I would, Ms. Lohr. You might have information that I lack.
I'll also use my prerogative and not to comment why that hasn't passed, other than to say we'd like to see that happen. For Dr. Al-Hibri, please comment on the widely perceived view that the Quran gives men's testimony twice the weight of women's testimony. Is this accurate, and what is its basis?
Well, there is a Quranic verse which, on first blush, seems to be stating exactly that. However, we understand now from having studied the Quran that there are various levels of meanings, various ways of interpreting, and in fact, I might mention that there is a paper sitting outside that is exactly on this issue concerning women's witnessing. And I could speak from precedent, and even in medieval times, some judges have been satisfied with a single woman witness. There's a lot of surrounding circumstances that need to be taken into account in interpreting that verse. And once understood properly, at least my point of view, is that it doesn't say that. Now, let me just say one little thing here. What do I mean about my point of view and other people's points of view? Islam does not have a church. We do not have an ecclesiastical structure. We do not have somebody, central figure, who's going to tell us how to interpret the Quran and how to think. In fact, the relationship in Islam is direct between the Muslim and God. And anybody, including women, men, etc., I don't know what the etc. is about, but anybody could interpret the Quran so long as you satisfy two conditions, knowledge and piety. So, in other words, anybody is open to looking at the Quran with knowledge and piety, and in particular to the verse you mentioned, to come up with their own interpretation or ijtihad.
This is another form of the earlier question. It's one directed at Akila Jaraya. Do you, Judge Jaraya, have suggestions for how human rights groups from outside the Muslim world can work with Muslim women's groups and in Muslim countries without disadvantaging them in some way as having worked with the West?
Tunisian Association accept all kind of help from all countries. Tunisian Women Association can, for example, chair all seminaries about the struggle of women in the world. They can share with them the ideas, the plans to the future for the development of this emancipation and of these achievements in Tunisia or in the world of the women. We share of all kind of association this struggle in the world about the emancipation of the women.
Thank you. Huda Kanoun, Justice O'Connor spoke of the need for a unified voice in bringing about change. Using the Tunisian model, realistically, how unified are Muslim women activists in countries throughout the Islamic region?
Well, we are trying to work hard because women has never had, such strong networks as we have today. And we have all the NGOs practically, and we have in Tunisia as well the Center for Information, Documentation and Research about Women, and the Arab centers and so on. There are so many structures that are dealing with the NGOs and that are pushing horizontally certain thoughts and certain ideas. And we do meet from time to time and we do work together.
This is open to a few of the panelists, actually, so I'll open it to whoever would like to answer the question. Is there anything that American groups can do here in the United States and the American legal community to help Muslim women abroad who are suffering from discrimination in their own countries?
I could start on that because I'm actually working on it. There is a situation here involving Muslim women in American courts when we have divorce cases. And while the law is pretty protective or egalitarian with respect to women in the United States, there are situations where American Muslim women have found themselves in trouble in cases of divorce. One reason I took a tour to 9 Muslim countries is to try and discuss a solution for the Islamic jurisprudential issue that underlies these problems. Everybody wanted to help me, but the trick was that this is not a unique problem to America. And it became clear that if we solve it here, a lot of other countries are willing to adopt the solution. And women were very happy to see that their religious leaders were open to this kind of consideration. So I think that American women, especially Muslim women, could develop a jurisprudence which is egalitarian and which will then be used as a model as well as your Tunisian model and other models in the Muslim world for other countries.
One other question for Justice O'Connor, which is on a personal nature. I think when people have the opportunity to ask the Justice a question, this is something that's irresistible. Can you comment on the discrimination that you have faced in your own career?
Well, I think I mentioned during my remarks earlier that when I got out of law school, I had always assumed I wouldn't have any trouble getting a job as a lawyer. I think that was very naive. I was pretty young, and I didn't realize that it might be hard to get a job, and indeed it was. I learned that none of the law firms in California, where I went to law school, had been hiring women as lawyers, and they didn't plan to start doing that. So that was a surprise, and the first job I got was in the public sector as a deputy county attorney in San Mateo County, California. And I had to work very hard to persuade the county attorney that he needed me on his staff. In fact, one of my letters to him urging him to hire me has apparently was saved because the Historical Society of the county wrote me last year and said they had it and wanted to display it. So luckily, I got that job, and it was really wonderful, and things went on from there. But goodness, I went to Phoenix with my husband in 1957, and none of the firms in the Phoenix area had hired a woman as a lawyer. So we were back where we started, and I had to open a law office with one partner in a suburb of Phoenix to be in the private practice. So things didn't really open up until, I think, late 60s, probably, and early 70s, which shows how recent some of these changes have been.
But it has all worked out, hasn't it?
It worked out pretty well.
Yes. Okay. Dr. Al-Hibri, in the nature of the questions, there is an interest and a need for Americans to help women in the Middle East. Is this thinking helpful to try to understand the Arab world? And also, is the discrimination against women in the Arab world only by Muslims against Muslims? Discrimination by Muslim men against Muslim women?
Let me start on the first part. The need on the part of American women to help women in the Muslim world can be interpreted in many ways. The best face one could put on it, and it's a reasonable face, is that women in the feminist movement believed as part of their basic principles in the sisterhood of all women all around the world. And therefore, if I see a woman suffering anywhere, then it is part of my duty to help. I think that's a good sentiment. The question is, how do you do it? We don't want to get into the situation of we're trying to save others despite themselves or something like that. But the basic feeling that we're all sisters is a very important feeling. The discrimination against Muslim women, is it only happening in Muslim countries by Muslim men? Let me answer what I think might be behind this question, because I really don't understand it. Let me say that there is a lot of discrimination and oppression in many Muslim countries, and it does not affect women alone, and not just Muslim women alone. You cannot really talk about the liberation of Muslim women without talking about the liberation of Muslim men as well. We really need to have a humanitarian set of demands. We need to agitate for democracy, for human rights and women's rights amongst them.
And our last question is for Huda Kanoun from Tunisia. You mentioned in your remarks that the personal status code has undergone some challenges and changes. How firm do you think it is now and for the future of Tunisia?
Well, the personal status code is quite strong in Tunisia, and the 1989 elections, which I was talking about, shows you that it is something which is really deeply rooted in the Tunisian society. But there again, it is deeply rooted and things come and go. We have to support it, we have to continue striving, and we have to deal with politics because, you know, at the end, it's a question of vote, it's a question of parliament, it's a question of public opinion, it's everything together. So we have to strive to keep, consolidate and improve our status, and we have to strive with all the women in the Maghreb, in the Arab world, in the world at large.
Thank you. And thank you to all our panelists and our audience. I know there are some other questions, but time does not permit that discussion. For those of you who would like to discuss this issue even further in another setting, I invite you to join Douria Gadi Ali and others at the State Department tomorrow for an open forum on Islamic feminism, featuring BJ Farina, who is here with us today. So please join us at the State Department tomorrow. Many thanks to our keynote speaker, Justice O'Connor, our panelists, and our audience for a wonderful, spirited discussion. I'd like to turn the podium now over to Ambassador Robert Pelletreau, who's president of the board of the Hannibal Club.
On behalf of the Hannibal Club, let me thank you, Justice O'Connor, for hosting this very special event today that kicks off our fall season of activities, not only for hosting the event, but for participating so generously in it, and for being for all of us and setting the standard in word and in deed. We thank you. And thank you, Justice Jaraya, Deputy Kanoun, Dr. Al-Hibri, for giving so generously of your time to join us on this panel. We have outside copies of a number of the initial speeches that were given today, which you can pick up and take home to contemplate at your leisure. And we would like to invite all of you to join us right across the hall for a reception and informal discussion with our panelists, where you can ask the question that you were a little hesitant to ask in this formal setting. Thank you all for coming, and see you next door.